Hey, Kate Waterford. Today we are going to be talking about birth trauma and legal action. It is one of the biggest conversations that we see occur within our community. And so we felt it would be really important to bring this conversation to our network and answer their questions. So, Kate, before we get started, can you please introduce yourself?
Hi, Amy. Thanks so much for having me today. So, as you know, I'm the former board chair of Birth Trauma Australia, and I'm also the managing partner of Malagana Edwards Johnson in Canberra, which is a law firm where I run the medical negligence practice. Always acting for plaintiffs, so always acting for people who've been injured and their families. And I have other experiences that are a bit relevant I might draw on in our conversation, like I headed up a quality and safety committee for a hospital previously and have been involved in various boards in the healthcare sector.
Brilliant. So we're in very good company. What we thought is we would reach out to ABTA members or ABTA BTA members now, and we wanted to ask them what questions that they would have for you. So we've bunched a few questions together, and we're going to sort of list them as topics, so people can skip and choose to what they're most interested in. But I think just again to sort of set the scene, what led you to specialize in birth trauma or medical negligence per se?
So, in a professional sense, I have found it absolutely fascinating and a real privilege to work on cases where people have had their lives catastrophically impacted by something going wrong in healthcare systems. So, I think it's really interesting to work at that intersection point between accountability and harm and try to look at ways that systems need to improve. But in a personal sense, I'm a mum of three kids. So that means I've had three births and a lot of other experiences that give me my own real sense of passion and commitment to uh, working for women and families who have been through these sorts of experiences.
Thank you so much, Kate. Um, can I ask, when it comes to medical negligence and birth trauma, how often do you see birth trauma cases within your practice? Have you seen an increase in the number of women seeking legal action or women and families seeking legal action?
I think there's an extraordinary increase just over the last 10, 12 years that I've been, that I can look at. Uh, we used to have an occasional birth trauma case, and they have increased over the years to the point where these days it would be a rare week where we don't get somewhere between 3 and 5 inquiries from people trying to investigate their rights.
Mm,
Not all of them would go on and have a claim, but certainly there's a lot of people out there asking more and more the question of, was what happened to me right? And
mm.
do I have rights to compensation that arise out of that?
That's really interesting. I think maybe so people can get more of an understanding. Can you sort of help us understand what counts as negligence in birth? So, how do you define medical negligence in the context of birth?
The definitions do vary a bit around Australia. So there are all different definitions and tests in every jurisdiction, but they have a lot in common too. And basically, across all jurisdictions, what we'd be looking for is that a clinician or a healthcare system fell below the standard of what can be regarded as reasonable and competent based on what they knew at the time.
Mm,
So it's not about some shortfall on perfection. It's not about finding something they could have done better. It's about whether they met that reasonable, competent professional standard.
mm. So, can you put that more in layman terms? Reasonable, competent, profession of standard. What does that look like?
Well, what it means is that the law recognises that giving birth is not a risk-free scenario. And sometimes things go wrong even when you've got the perfect team acting in the best possible way. So there are risks involved. But the obligation the law puts on them is to be reasonable and competent. And that means that when it comes to judging, for example, whether an obstetrician has been negligent, we're going to be talking to other obstetricians about what in all the circumstances would be reasonably expected for that patient and whether it in some way fell short. Or
Mm,
if it was a midwife who is thought to have done something wrong, we might be talking to other midwives to say, well, how are people trained in this area? Was this normal? Was this reasonable? Did this meet expectations of the profession? And so on across all the different practitioners.
Mm,
And sometimes as well, we don't look at it so much as an individual who was negligent as the system that was
mm,
negligent. Did the
mm,
hospital overall provided a standard of care that can be regarded as competent and reasonable in the circumstances?
That's really interesting. Um, do you like it? So if you're reaching out to other obstetricians or other midwives, what is the process? How do you connect with them?
So because we do a lot of these claims, we have people we work with regularly.
Okay.
But in cases that might involve some new or tricky aspect, or where our usual experts might be conflicted out, for example, we connect with medico-legal companies that actually operate at that intersection between medicine and law and help to put us in touch with people who might have that really niche area of expertise and who have expressed a willingness to write reports for court cases.
Okay. Okay. Thank you. Um, what are you, so based on that, obviously you've got some more common occurrences that you might see as negligence. Can you give us some examples of those sort of common cases?
I think it's sometimes helpful in giving these examples to think about the different periods we might be looking at. So
Okay.
we're still looking at the period that's leading up to birth. So you're looking about at how the pregnancy was managed. And in particular, were there risk factors or health conditions that were coming up in the pregnancy? How were they dealt with? Were they, were the risk factors properly addressed? Were there discussions? Was there information about warnings? Did the person who was going into giving birth properly understand what all their options were and the different risk levels that sat with those options? So in those kind of cases that arise from the pre-birth period, the things that go wrong are typically about missing problems, missing risks, or inadequately advising people.
Mm,
And then the second thing is, of course, the labour and the actual birth. So this is where perhaps the risk factors that are arising in the actual labour and birth period are not addressed. Perhaps women are left to labour too long, and that might mean that issues that could be managed in a fairly safe way emerge into much more dangerous emergency situations, which puts mum and baby at greater risk of harm. It could be things like inappropriate use of drugs or inappropriate use of instruments.
mm,
It could be about delayed response to abnormalities on the baby's heartbeat. So obviously when there's an emergency arising with the baby, you need to get on top of it very quickly to avoid any injury to the baby's brain. So that might be about clinicians not being around and present to respond, or ignoring red flags or responding too slowly. And sometimes it's about surgical errors as well. And
mm,
then finally, I'd say we have cases that arise where everything's gone well actually in the lead up to birth and in the birth itself, but something goes wrong that's mismanaged in the period after birth. So this might be there's a big tear that has been just missed and nobody takes any steps to operate it while there's a window of opportunity to get a good repair done and to get a good outcome for the patient. And instead, they're sent home from hospital with problems inadequately addressed, and that can make the problems much worse later on.
mm.
So any of those things can happen. Every birth is individual, and so is every case that we look at. But those are typical kinds of things.
That's really, really helpful. Um, is there a way that parents can tell prior to maybe speaking with a lawyer when is there a way for them to tell that something wasn't right? Ye-
I
Yeah,
think so, yes. And
yeah,
I would always say trust that instinct if you have it. Of
yeah.
course, it may or may not turn out that we can prove negligence,
Mm,
but often it is that instinct of feeling something was not right here that
mm,
does lead into investigations that are where we're able to establish negligence. So there might be things like, why was there so much urgency? Why did these issues not come out till later? Maybe a health practitioner in the room actually made some comment that leads you to understand that something here was not right and not normal.
Mm,
Perhaps you end up getting records and it doesn't match up with what you were told or what you experienced and remember. I think all of those things are good red flags that I would encourage people to trust their gut and go and get it investigated.
that's really good. Can I ask, so depending on the circumstances surrounding the birth, whether it was mismanaged pregnancy, something that occurred during the labor and birth, or issues in that postpartum period, um, is there a specific time frame? I think it probably vary from state to state. But obviously we have women that immediately want answers and they know something's wrong and they're ready to speak to a lawyer versus other women that have muddled through, often for years, with very real symptoms of trauma. And they think, actually, I do want to speak to a lawyer. Is it too late for them? Is there a period of time where it becomes too late to seek justice?
There are some periods, and certainly in some jurisdictions, that apply that limit the amount of time that you have to bring a claim. Having said that, I would encourage anyone who is feeling like they want to get legal advice to go and do it. Go and
Mm,
do it as soon as you can.
mm,
Uh, I think cases are better prepared and overall more likely to be successful when we do get involved early on, because then we can look the whole way through at building up the most successful case.
mm,
And there are also often notification periods and procedures that we have to comply with all the way along. For many jurisdictions, there's also around a 3-year limit for the registration in court. Like you said, it does differ a bit, but 3 years is often the time limit. Having said that, even if 3 years have passed, if you're feeling like there is something there to be investigated and you're not sure where you stand, I'd always recommend giving a call to a lawyer just to find out. And one of the reasons for that is that most jurisdictions have rules around what's called discoverability. And
mm,
discoverability is really where you find out at a later stage that your injury is more complex than you thought, or that your injury includes diseases or disorders you may not immediately have become aware of, and so slow diagnoses. And also, you might only find out later that there actually was negligence and that these conditions that you've sort of tracked back to something that someone did wrong.
mm,
So, in those sorts of scenarios, often there are rules that we can tap into that give you longer periods where the time only starts counting from that point that you became aware. So if I get a call from someone about something that happened 4, 5, 6 or more years ago, I will still look into all the circumstances and see whether any of those rules apply to give the person more time.
mm. It's kind of interesting because I suppose the other way to look at it is take, for example, somebody does choose to seek legal advice because they have got injuries and perhaps they have managed them. They've had difficulty, but one of the things that we hear a lot is the difficulty in obtaining a diagnosis. A lot of women that we support that have ongoing either birth injuries or physical conditions from birth end up with poor mental health because they are struggling to get a diagnosis. So through that period of time, whether it be a year postpartum, 2 years, 3 years, 4 years, if they are fortunate enough, because it's fortune, luck, financial stability that enables you to seek support and get that support. They would often be connecting in with a range of clinicians in those early postpartum years, from mental health clinicians to maybe pelvic health physios, colorectal surgeons, or urogynecologists. This is all still building a story, isn't it? I can imagine. So that all of that kind of information would be used towards a case. So in some ways that doesn't
So
write
some of
off.
those events you've described can give people more time.
Yeah. Um, but in those circumstances, we're curious to know what about fathers and partners? Can they be involved in a litigation case? Because, if I had a dollar for every time a partner of somebody giving birth that says to me, the birth was, they'll tell a quite a impactful birth story, but they'll say, it didn't happen to me, and they'll dismiss their own experience. And yet we know the impacts of trauma on the brain, in many cases for fathers and non-birthing parents. They fear for their loved ones. They fear for the life of their loved one, either the partner or the baby. That is a very real trauma that can cause real trauma symptoms. So is there a case there for fathers and non-birthing parents?
So they often have rights as well. And in
Yeah.
fact, it's common. I would go almost as far as saying that it's in the majority of birth trauma cases, that there's a second claim run by someone like a father or a partner. It could even be a sibling or a parent or someone who was in the room and actually suffered that psychological trauma
Mm,
of watching the events unfold.
mm,
They have their own legal tests, but usually it's about the relationship and the situational proximity, so the closeness to the event such that they experience their own trauma.
mm,
Uh, and they're called by different names. So you'll hear them called pure psychological injury claims. You'll hear them talked about as secondary plaintiffs. And you'll also hear them talked about as nervous shock claims. But
mm,
all of those are going to describe a claim for compensation that arises out of having suffered a traumatic psychological injury
mm.
when witnessing someone else get injured through negligence.
Mm. Okay, well that sort of leads quite well to my next question, which is obviously I've just spoken about injuries specific, so that's something that you can measure, physically see. Do people have a case if they've experienced psychological trauma, where, often women that we support talk about certain things that occur, like there are always themes. Those themes can include emergency situations, a lack of informed consent, feeling coerced into making decisions. Some women will even talk about obstetric violence. Is there a case for that? And is it harder if there isn't, I'd like to say not, because we have such a huge understanding of perinatal mental health these days. It goes without question. But do women have a case if it's psychological injury?
I would say potentially yes.
Yeah.
So those kind of cases don't stand on their own separate principles as such. They
Mm,
stand on the principles that I've outlined earlier, which are we have to prove that there was some kind of negligence.
mm,
Just like I've talked about how birth has its own inherent risks of physical injury, even in the best of circumstances. So you could also say that pregnancy and birth have their own inherent risks of psychological trauma, even in the best of circumstances.
mm, mm,
So it's only one part of what we have to prove to show that the person has experienced that trauma. It is essential that we also link it back to what the hospital or the doctor, etc., did wrong. So
mm,
show that there was that error, that oversight, whatever it was, that actually amounts to that legal negligence and that caused the trauma. But
mm,
yes, certainly we've had cases that we've run on even the mother having only pure psychological harm, uh, distinct from any physical injury.
mm. So I guess this is a tricky question, but in the case of informed consent, so you're talking about risks of pregnancy and birth, and yet now we're coming up to a decade of providing direct support to families that are impacted either psychologically or physically from birth. If I have heard over the years so many times, we don't discuss risk with women. Birth is a natural process. And it's still so divisive, this conversation. Um, how difficult is it to make a case for lack of informed consent? Obviously, might be helpful for people listening for you to touch upon the Montgomery and Lanarkshire case in the UK, because that did change that kind of conversation in the UK, but it doesn't seem to have kind of like reached our shores, this conversation. So what are your thoughts around that?
So, and the UK and Australia do have different laws, but they draw on common principles and ideas behind them. So, uh, when that case came out in the UK, and that was a case where a woman had been inadequately advised and warned and inadequately informed about options
Mm,
leading into her quite risky birth of a
mm,
large baby.
mm,
Uh, it attracted a lot of attention here in Australia as well. And the findings in that case essentially were that it hadn't been a matter for the doctors to decide at their liberty that they would not share information and choices with the patient, that the patient had her own right to be actively involved in decision making as between treatment options, and that their act of depriving her of that choice had actually led to her injury. So it was a really important case, and in fact, that judgment, I don't have the exact
The
quotes to
wording's
hand.
powerful. Yeah.
It's
Yeah.
beautifully written. Some really empowering statements in that.
Yeah.
I know that Birth from Australia has published on some of those a number of times before. But here in Australia, we have our own rules that even go back quite a few years in medical negligence cases outside birth trauma scenarios that do clearly state that doctors have professional obligations to provide a reasonable level of advice in relation to any medical treatment or surgical procedure, and that would include birth, absolutely. So sometimes the negligence, there can be actual negligence associated with a failure to provide information. And if we can link that to harm that was suffered, that's one kind of case that can come out of that. Also, there is this approach, which is a failure to warn leads to an absence of informed consent, which means that the person actually wouldn't have proceeded in the same way with their treatment or surgery or birth because of that absence of information.
Mm.
And in those circumstances, we can actually claim that all of the damage that flows from that course of action is something that the doctor has to compensate them for. So an example would be I think of that very case, like the UK case we've just mentioned, if that played out in Australia, I can very well see that that woman would argue that there was an absence, a failure to provide appropriate warnings, therefore there was an absence of informed consent going into the vaginal birth, where she should have had proper levels of information about the risks she faced, and that then caused all of the damage that flowed with the physical birth that preceded. Sometimes it can get a little bit tricky proving exactly what would have changed. So
Yeah.
what information would have changed. I'll say that a lot of people will say, oh, of course I wouldn't have gone ahead with XYZ if I had known. But it's not taken for granted in courts. It's something we actually have to actively persuade the judge about, that information would have changed the choices that the patient made, and that therefore the harm would have been avoided.
I can imagine that's quite a difficult conversation to achieve. Like how can you really prove that? Because I do hear so many stories of women saying, like, I was really open to the type of birth that I would have. And also that disappointment around feeling, some women do talk to us about feeling coerced into a particular type of birth. This could be cesarean, it could be vaginal birth. Yeah, how do you sort of navigate that? Yeah, it's a tricky one.
It is an active thing we have to ask. It's an issue that we have to inquire about, and we have to grapple with it, and we have to talk to our experts about it, and we have to really solidly understand it with our clients. So what will this information have changed? What expectations did you go in with? You may have had a birth that was different from what you would have liked, or what you had planned, or what you had hoped for, or maybe what you got in the first round. None of that necessarily is something that we can hold the doctors accountable for.
Mm,
That is the nature of pregnancy and birth. It
mm,
is, it is fraught with different kinds of risks, and there isn't necessarily any right answer in terms of how it should proceed. But the question at law is, did the doctors meet a reasonable standard in the information they gave about the options, not just in a general objective sense, but right for that person with their particular values, their
and their
needs, their
profile. Because if we're not telling women about
absolutely.
risk,
Yeah.
we're also not applying individualized care because, like this came out in the New South Wales birth trauma inquiry that we shouldn't have a one size fits all approach to birth, and yet still very much post-birth trauma inquiry, there is very much that approach to we are going to make the assumption that this individual is going to have the best outcome, say, for example, if they have a vaginal birth. But we actually know some significant risk factors that may come into place if they're at risk, say, for pelvic muscle dysfunction. So it's
That's absolutely right.
yeah,
That is true under the law.
yeah.
There is no one size fits all requirement for advice. It is personalised, and there is a really strong High Court authority for the fact that that advice needs to be personalised to the individual needs of that plaintiff.
Mm,
So no birth is superior,
mm,
and no birth is right for everybody.
mm,
Some people, even properly informed of the risks, will make choices that would be different from the ones the doctors might want them to make or the midwives might want them to make. But that's not the point. The point is, did they have the proper information to proceed with that decision?
mm. Hey, I want to talk to you about assisted births and legal considerations. I heard that because New South Wales, for example, has the consent guidelines, and if they are not applied in this hospital context, does that increase the possibility of I don't know if you can even call this, but a successful litigation. If someone's had forceps, but they really don't feel like they've properly consented, maybe even if they've signed a consent form, what is there sort of more nuance around that because New South Wales has this consent manual?
So, a person may still have a case in those circumstances, and there may be even some elements that are stronger if those procedures haven't been properly dealt with, and the information that's now regarded as standard or required statewide isn't provided with to them. But even signing a consent form doesn't do away entirely with your rights. There can still be instances of negligence that occur in those situations.
Okay. Um, What happens if a parent feels like they were pressured into making decisions? So, again, we hear it a lot, being pressured into having an induction without being properly informed of what that may mean, being pressured into instruments or into cesarean section. Is that something that you come across in practice?
It does. And I think often people who are pressured into decisions may have a case that comes out of those events. So I
Mm,
definitely think it's worth going and inquiring about all of the circumstances. Again, the fact that someone feels pressure is a little bit different from establishing that the doctor or whichever clinician it was or the hospital actually was negligent or that they did something inappropriate that we can legally link to the harm. Do
mm.
have to get through those tests still.
Yeah.
But um, but one thing that we have often looked at is, okay, so a lot of the pressure and that feeling of urgency came from the situation, the emergency that was unfolding and the way that the clinicians were responding to it. But if we're looking, for example, at the standard of care that the hospital provided as a whole, were these things that should have been anticipated earlier? Were there
Mm,
things that should have been dealt with in a non-emergency situation earlier at a time that the person had more time to psychologically prepare themselves and
mm,
to engage with the decisions in a non-emergency environment? So
mm.
uh, the fact that a doctor walks in when an emergency is unfolding, the baby's brain is being deprived of oxygen or something, you can't necessarily fault that individual doctor for demanding quick decisions. But if you look at that as a whole in terms of the care that that patient provided, then perhaps there has been a
Okay.
failure by
Yeah,
those
yeah.
things.
Okay, that's interesting because well, that leads me nicely to the next question, which is around medical records, missing notes, and that sort of documentation. So, lots of women in our community do want to obtain their medical records. They are seeking some clarity around their experience. But then they are re-traumatized because they feel like there's things missing, it's incomplete, it's inconsistent, or it's completely different to what they recall. And, as we know, having both birthed, Yeah, there's a lot that you can't remember, but you do hopefully in some circumstances have a support person there that will have their version of events, and they might be really different to what is seen in those medical records. Women do report to us that they feel that they are misleading. How do you navigate that? Because that is surely a case of this person says versus this person says.
I think medical records are absolutely the backbone of any case. They are essential. They do give us a lot of information, a lot of evidence about what was known, what happened, what was done, when it was done, what wasn't done. But of course, it is obviously all the time that they have errors or that things are missing from them. And so we have to deal with that on a case by case basis.
Mm,
So, there can be all sorts of reasons for that. And I would broadly put that into the category of, active choices by people who are preparing those notes to maybe not write everything down or to write things down that
mm,
aren't entirely accurate, but
mm,
also just sloppiness or late retrospective note taking and all of the errors that can climb into any sort of administrative document for those sorts of reasons.
mm,
So what our job is as lawyers, we have to go through that really carefully. We have to try to get information from our client and any other witnesses as well, and try to stack that all up to work out what portion of the clinical notes we might challenge or seek to add to as not being a proper record of the events.
mm.
Um, the records are important, but they're not the only evidence that a court would take or
Okay.
that a defendant would take into account. And so witness accounts are really important as well. This is not a psychological recommendation because I'm not a psychologist, but from a legal perspective, it is helpful if my clients write down in a lot of detail what they do recall,
Mm,
um, and probably as early as possible to the events as they can,
mm,
uh, and separately, not together, but as a separate exercise, the witnesses do it. What you don't want is everybody getting together and writing a common version of events because that actually contaminates the evidence a bit. But I do want to know what each person in the room is going to tell me about what they do recall, and think about how those match up. You
I think
also
that,
mentioned that
yeah,
people can actually find it quite traumatic to go over their own clinical records.
yeah,
I'll say it's not essential that they do so. That's part of the lawyer's job, and not all of our clients would go over their own records. But
mm,
obviously, it's something that's often happened before they've even come to us.
yeah. There's a couple of points there. I think that trauma of reading your notes, even when I obtained mine, I remember looking at the signature that consented to forceps, and it was definitely my signature. And I have absolutely no recollection to ever signing that. And that in itself is just so confronting. But also something that you've touched upon there for anyone listening to this that's really tangible is taking that time to write down what you remember occurring through the management of your pregnancy, through what happened in labor and what happened during the birth and postnatally, and doing that as soon as you feel able to. I think that's really powerful because I guess, like you say, if litigation did become something that they were considering, it's a powerful a piece of evidence. But also, there's research that suggests that it can be really helpful as well to kind of release that. So it kind of has a two-pronged approach. So that's really good advice, and also encouraging the support person, non-birthing parent in the room to do the same. So I feel like that's a really tangible activity that anybody can do right now if they're listening and thinking about legal action. Um, uh, are hospitals ever held accountable for poor or missing documentation?
Yes, they can be, in the sense that quite apart from the civil cases that we run, where our objective is to get someone compensation, there's also a line of legal actions that can involve tribunals and can involve the various professional regulatory boards. And one of the things that they can look at is the individual professional obligation to maintain accurate and contemporaneous records. So there have been in quite a number of cases that have gone through the tribunal that have actually involved disciplinary action against professionals for inadequate record keeping. And to some extent, that can also happen in relation to hospital through the various state-based agencies that are charged with that kind of oversight role.
Okay. Have you got advice? So say somebody gets their medical records and they just feel like it's all lies. What would be the next course of action in that circumstance?
Probably going, first of all, writing down for their lawyer or for a potential lawyer what their recollections are, and as soon as possible trying to get down what they believe is missing, what they recall about those missing events, what they believe to be inaccurate, and so on. Now, we all know that memories fade over time, even in the best of circumstances, but perhaps even more so when the events are traumatic, and when you've got all the hormones and other physiological factors associated with the birth going on. So it's good to have those things written down when they're fresh in mind. And then you can work through it with a lawyer to ascertain whether the problems are things that can be overcome.
What about in a circumstance where something that we frequently hear is the denial of pain relief? You did touch upon this earlier on, where you said misuse of pain relief. There's multiple ways in which that can be misused. But that denial of pain relief and women then getting their notes, they're told that it's too late, say, to have an epidural. Then they get their birth notes and discover that they could have had one. But they were told and they recall being told that it was too late. How have you ever dealt with situations like that?
Potentially, I guess it goes back to basic principles. In all of the circumstances that were unfolding in that person's labour and birth, was it reasonable? Did it meet a reasonable, competent professional standard
Mm,
by whatever framing the state or territory has,
mm,
um, for the hospital not to have provided that pain relief,
mm,
and even to have given that person inaccurate information about whether pain relief was still an option, and linking that to the actual harm that they suffered. So did they suffer
yeah,
PTSD because of that
yeah,
intense, extreme experience of pain that should have been avoided?
mm,
If you could establish that, then potentially there would be a claim out of those circumstances.
okay, yeah. It's making me think of exactly that case, and the subsequent psychological impacts of that. Um, okay, last few questions, Kate. Um, can describe this convey. Okay, this is a good one with regards to, I guess, making a complaint versus going down the legal action route. Is it better to go through the hospital's complaint process first or speak to a lawyer early? I don't know if this is a conflict because obviously you're a litigation lawyer, but what are your thoughts around that?
Given a choice, I'd probably prefer to speak to people beforehand.
Mm,
Uh, so because I get lots of different inquiries from lots of different people about birth trauma claims, I do often speak to people very early. Sometimes people even call me from the hospital after they've, just given birth practically, or their partner does. And sometimes I speak to people after a few weeks or months or even years have passed. If I can, I like to give them some information that will help them to prepare for that discussion session with the hospital. And there can be different names to that. Of course, it can be framed around a complaint. It can be a debriefing session that's provided after some period has passed, etc. But I find that if I've already at that point had a detailed discussion with them about how the law works, what to expect, what to get out of the information, and also often if they've had an opportunity to really think through clinically, perhaps with my assistants, what information they're looking for, um, that can make it a more productive session.
mm,
Uh, but where it hasn't happened, that's fine. It's not an issue. We can still proceed further from there. I don't encourage people to go into that advice, that debriefing session, and talk about advice that I have given them, because that
mm,
would be waiving their confidentiality around the advice, which is actually really problematic. And I wouldn't encourage anyone to actively tell them that they're developing a compensation claim, because that might actually make the hospital clam up about what they're willing to say.
Mm.
So a little preparation is good in my experience, and I do prefer that if given a choice.
Okay. No, that's helpful. Sorry. Next thing, I guess, is that people kind of want to know what the legal process looks like. So, can we sort of run through that in terms of what happens when someone first contacts you? Um, let's start there, I guess. What happens when someone first contacts you?
I'll try to give some answers that are of general application. So if I were talking to a client that were in a specific state, I'd probably get more technical about exactly what the procedures in that place involve. It does differ from place to place, so it's important to get that information. But if we just look at it in broad terms, that's common everywhere. Usually somebody would approach me. Most law firms that act in this area will give some kind of free consult to help people just get a sense of what their rights are. And that will give you a sense of, is this something that could be potentially investigated further or maybe not? Once they've reached the point that they do want to proceed with the investigation, they'll have to go through formalities of actually retaining that law firm, so signing documentation. And then they'll probably sit down with the lawyer and work out a plan for the early development of the claim. So typically it would always involve going and getting the clinical notes, but it might be just from the hospital. Maybe the person's already got it. It might be other doctors or other health practitioners. Maybe we need to go get the hospital records from a different surgery where a repair surgery was done. We put it all together so that we as lawyers can look through it and have a really good understanding of what those records say happened. And we might also be taking, as I said, witness statements or gathering other information from other sources to put together that picture. There then will also be usually a process of connecting with experts to get independent medico-legal opinions. So that's working out the plan for how are we going to win this case with expert support. Are we going to be able to establish there was negligence? Are we going to be able to establish medically that that negligence caused injury and harm? And how do we link that up with all the various other losses and disabilities and the impacts that people have suffered on their life since these events occurred? So we might be working out what sorts of experts are appropriate to the case. We might be connecting with them, checking for conflicts of interests, arranging reviews by the experts, and then feeding that information back to the clients and working out where we go from there. There's probably a period where we've developed the liability case, so that kind of evidence up to the point that we need. And then we might be gathering the other evidence that tells the story and proves the losses that we're going to be including. At some point, hopefully before court, once you've dealt with any other requirements that need to be dealt with in that jurisdiction, you're then also going to be connecting with the defendant, putting forward your case, putting forward the evidence, and hopefully having an opportunity for some pre-court settlement discussions if the person is ready for it. The timing for that readiness is going to be different from person to person, because typically with these cases, the claim is finalised with a single lump sum. And that means that at the point that you achieve that lump sum, you're going to want to have a really good understanding of what the future looks like and capture all of those future losses as well. It would be a bad outcome if you settled a claim and then found out the following year that you're going to need a whole additional line of surgeries, for example, that you hadn't included. You couldn't reopen it. So sometimes claims resolve there through direct out-of-court discussions, and sometimes they get commenced in court. And once they get registered in court, it's an oversight by the court to work through a timeline through to, in most cases, a mediation. And it's only a very few cases that ever end up in court hearing. As you know, Amy, because I know that you're always on the lookout for cases like this in Australia, it's only the tiny tip of the iceberg of the overall claims brought that end up in a courtroom and a court judgment.
Mm. Okay, so just to backtrack a bit, because you've covered a lot there. Initially, when they contact you, you're having a conversation. If then you go away, you're checking the validity of the case. You've kind of made that whole process sound like it's quite quick. the reality is, let's talk about a time frame because I certainly know women that have they really do want to seek compensation. They know that their life is beyond compromised and completely changed. And then their lawyer is taking quite a long time to come back to them and even let them know that there's a case here.
Yes. I think for those people, I would encourage them to connect a little bit with their lawyer and actually understand what's going on,
Mm.
because a long period of silence may or may not mean that the lawyer is doing things. Of course, it's possible they've just been forgotten, I suppose, theoretically, but it may also be because a lawyer is actively investigating all of these different things. Um, Medical negligence claims can be quite complex, and quite a lot of legal effort does have to be put into that analysis and that building and that investigation and connecting with experts. It doesn't usually happen overnight, except in cases where it's really urgent and we're all battling to get to a deadline. But also the legal process often follows the medical process. So if I take on those cases where they have contacted me in the few days after the events and I've signed them up, when they're still under a month past postpartum, it could be medically a good year or two, or sometimes even longer, before they've even got all of those full diagnoses from their doctors. And that's even where they've got a lawyer behind them actively encouraging them to go and get proper medical advice and so on. Sometimes time just has to pass for the full impact to be understood.
Okay,
We
so
we
I
have
did, yeah.
to run through, rush through that.
Okay, sorry to jump in. I didn't pick that up earlier. So, I was saying if they don't contact you until 3 years down the track, sometimes that's built the case, right? But if they contact you earlier on, you still build because they've still got to obtain all the diagnosis. And I suppose in a way, they would kind of have you guiding them on what clinicians they may need to see, whereas for so many women, it is just pot luck on who they are referred to. And, not only pot luck, but also, I guess, having that, women talk to us about being dismissed when they go and see a care provider, when in fact, actually, they need to be referred to a colorectal surgeon or referred to a psychologist. So in a way, it's kind of helpful because you're helping them actually get the support that they need. I think I'm hearing.
Absolutely. I'm
Yeah,
not a doctor. I'm not going to go
yeah,
give people referrals to scans or
yeah,
specialists.
yeah,
But before I had entered into this line of work, I don't think I'd ever even heard of a urogynecologist.
yeah,
What could a colorectal surgeon possibly have to do with birthing?
yeah.
But having seen all these cases go through, we do have a good sense of, what types of
This is who you might need to
conditions
see. Yeah.
usually arise and what types of people they usually need to see. So we can definitely be there to help do what we can from a legal perspective, at least to see people on that journey. And then to gather, of course, the information as much as we can along the path. And there have even been cases where, a person is not able to get referrals from our own treatment team, but we have managed to arrange a medico-legal assessment, which is a bit different from treatment, that will help to give a better picture of everything that
Why
is
can't they
going.
get referrals from their medical team?
So there's a separate process for treatment. So treatment is something that you get, that Medicare would cover, that you're going to get because you want a diagnosis and you want to get treatment or therapy that follows that. And everything associated with that process, like getting scans and tests done and things, all the usual things you would do even if you don't have a case. That stands separate from what we call medico-legal assessment, which is usually when you go and see a person once, maybe a couple of times over a period,
Mm,
where the objective is not to get treatment, the objective is to get a report that you will use in the case.
mm.
So that person's job is to do an independent review and write a report for the case.
Okay, I'm hearing that. What I have heard from women that have gone through this process is actually, I think it's really important to acknowledge how difficult this can be for some because what I'm hearing is so obviously women are going to see clinical experts that are going to provide information both for the person seeking legal action and the individual or organization that what do you call them? The plaintiff?
Yes.
Yeah. So I have heard stories of women, yeah, really being dismissed by the practitioner that is assessing, say again, a physical injury, say for example, and these are the stories that I hear from my community, where they have actually minimized their trauma. And like, I don't know what the ethics is around that, whether they just do it because they themselves don't actually understand the psychological impact, or whether they do it because they are akin to doctor. I do hear these stories, and I do hear that, going through this whole process of seeing multiple clinicians to kind of prove your trauma can actually be really taxing. Like, what advice do you have surrounding that? Because it is a slow process. Um, and you just can't determine the outcome. Do you have advice around that?
Look, I think it's a really good point, Amy, and I think that everybody who's going through a case or thinking about going through a case should think through it and probably, talk to their lawyers about those kind of emotional support needs they have around the case. Lawyers are people who are, of course, looking at court judgments and statutes and thinking about processes and paperwork. There's a human in the middle of all of
Yeah,
this, or multiple ones, and it's not a tax law case. It's not a it's not a commercial transaction. It's a person going through one of the most vulnerable experiences of their lives as they
yeah.
come to terms with disabilities and all sorts of things. It's really raw. So that can be really hard. And I think you can have the best lawyer in the world and the best case in the world, and it's still going to be hard.
Mm.
Um, a good lawyer, I think anyone who goes into this area is probably going to be somebody who's quite motivated by compassion and hearing people's stories and wanting to be supportive of that process. Because over the years, we've had many clients who've struggled in all sorts of different ways with different aspects of it. But that support doesn't come solely from an understanding lawyer. It obviously, in some cases, means that you need a support network around you in your personal life. It might mean that you need to have some therapy around it. It might mean that you need to work through some of the aspects of it with other people in your care team. You're right, medico-legal assessors can be brutal. I
Yeah,
would hope none of the ones that, you know, the law that we ourselves are engaging with, but typically we hear some bad stories about defendant medico-legal
yeah,
assessors.
yeah.
So when you're preparing for that sort of assessment, it can be good to do some groundwork in terms of what to expect and how to look after yourself properly through it. Certainly, if I ever heard that someone had treated my client like that and I was retaining and paying for them, I'd be outraged and would not want to use that person again. But it can be a really difficult and confronting process. There's no doubt about that.
Yeah, and I think it's what you're touching upon. So it's the defenses. That's the word I was looking for, not plaintiff defense. Um, it's their uh, medical experts that I think lack compassion or empathy towards somebody that's going through this process. And in my experience, the people that I've connected that have opted to seek legal action. Um, Obviously, I do connect with a lot of women that have physical injuries and the subsequent psychological aspects of that. Is the reality is they are living with a condition that has compromised their quality of life. It is going to impact for so many financial, your earning capacity, how you will live and age well, how you can engage with your family, with the broader community. So the ripple effects of this kind of birth trauma is extensive. And I think it's important to be realistic about how slow the process is. But the reality is, if your quality of life is compromised, it has to be a question, it has to be something that needs to be considered. Not an easy process for sure. And I think this again will lead on to that next question is you've got women that like I hear the stories and again a decade of hearing stories and they shock me and they also fuel me and my passion. But then they go to seek a lawyer, they speak to a lawyer, and then the lawyer will typically say, you could lose your house in this process, which immediately stops any thoughts of pursuing a legal claim. What are your thoughts around that? Can you sort of tell me, like, how do you navigate that conversation? Because obviously it is an important conversation to have. Um, what do you have advice around that?
Um, well, in one sense, I would say it's a little bit comparable to what we've already discussed around a doctor preparing or a medical team, treatment team preparing someone for birth. Um, it's a tricky process, but that person needs to understand what's happening. And they need to understand what their options are and decide which path is right for them.
Mm.
Now, the conversation that you've just given an example of sounds a really scary example,
Yeah.
and maybe that would be said in a very risky case. It's not something I routinely would say to my clients, but what I do is engage with them at the beginning and at all the other stages of development with the claim to talk about, well, this is where your claim stands. These are the strengths of it. These are the issues with it. These are the defences we can expect the defendant to raise. This is going to how we're going to work through it, and get help them to understand exactly where they stand and what might be coming. Cases that have some risks or difficulties to them, um, but still have some prospects of success, often do resolve by negotiation anyway. So it's about working through what your options are.
Mm. I think it is that perception maybe that they think it's going to go all the way to court. But I think, and correct me if I'm wrong, there hasn't been like a case like we've had in the UK that you touched upon before, where it has gone to court. So most obstetric litigation cases are settled outside of court, aren't they? So we don't hear about them. So we don't hear about people's successes. But the person that has received financial compensation for what they've experienced, they would very much count it as a success.
Absolutely.
Yeah,
That's
yeah,
and that for, for the vast majority. So the vast majority of people who have a good or decent case, that would be the outcome that you would expect. Um, each case is about us presenting and developing arguments supported by proof, where what we try to do is persuade the defendant that they're going to lose in court and that they
Mm.
should pay out money out of court. And that usually does happen.
Okay.
Now, of course, defendants aren't motivated by uh, great compassion and generosity for giving money to everyone who's been through some type of difficult experience. The whole system would fall over if it operated that way. And insurance companies are looking to minimise their outlay, but they do settle where they see that a valid claim has been made against them, and we have established that baseline of proof against them.
Does it probably works in favor for them to settle outside of court, doesn't it? Because they probably don't want it to get out that there has been a major compensation claim.
There are lots of reasons why defendants would settle outside of court or at a mediation rather than go
Yeah,
to a hearing. So reputation is one issue,
yeah,
and obviously doctors would feel very anxious about their errors being laid out in that public way.
yeah,
Uh, but also financially, just on a pure commercial analysis of it, an insurer will say, we think a person has a good chance of winning. And if they do win, then not only might they get even more damages than what we might be prepared to offer them at this point in time, but also we'll have to pay more of their
yeah,
costs
yeah.
and we'll have to pay all of our own costs. So that very final stage of a court case where somebody is actually presenting their claim in a courtroom, it's probably the most expensive in terms of the costs involved, because it might be a period where multiple lawyers are working on the case full time, for the weeks of preparation as well as the actual presentation in court. So that presents a great risk to the defendants because it's very expensive if they have to pay for that on both sides if they end up losing. And all of these things, um, I think it's important for people to understand a bit about that court process, but also not to be intimidated by it,
Mm,
because in one sense that's actually your power, that's your strength, that's
mm,
what you hold over them. You
mm.
are holding over the defendant the fact that you have legal rights that you believe that a court would enforce, and
Yeah,
the award you damages for what you have been through as a result of the wrongs they have done to you. So
Mm.
it's power in a sense.
That is really interesting. In the many people that I have connected with that have taken legal action, I know some have expressed that kind of regret that they didn't push it all the way to court, because I think they recognise, maybe retrospectively, there was a big case. But I guess we'll never know. We'll never know. But just on that rounding costs and funding. Can you talk about no win, no fee? Because I think the perception is there's no costs involved, but that's not actually the reality, is it? There are costs involved with a no win, no fee.
It can be.
Yeah.
So I want to talk about it in a general sense that is going to apply everywhere and that, that's not specific just to my firm, but the sorts of arrangements you could see anywhere. So typically where people talk about no win, no fee, they're talking about some kind of conditional arrangement where there are conditions attached to whether you have to pay that lawyer that's attached usually to a successful outcome. So if you don't get compensation at the end of the case, the condition won't be triggered that you have to pay them. And a lot of law firms in this area will agree to that. Now, some key things to keep in mind is that every jurisdiction around Australia has quite strict rules on what lawyers have to disclose around it. So there should be a contract around that, and there should also be various disclosure materials. And what's usually universal is an obligation to explain the rates that you'll be charging at, and the circumstances in which you'll have to pay and what can happen on various different outcome scenarios, as well as estimates about what the cost might be. And usually there's ongoing disclosure obligations, so you have to talk about that again if things shift through the course of the case. So you absolutely should get that information at the beginning of the case. And if you feel that your lawyer has rushed over it or that you've just been sent a document to add a signature to, do take the time to talk through it, walk through it, ask any questions that you might have. And if you find that your lawyer is not being transparent and not answering your questions, then maybe that's actually not a good fit at all for you.
Mm.
The other thing to keep in mind is about disbursements. So disbursements are often the amounts that have to be paid to third parties. So paying a doctor for writing a report or registering a court filing fee, things like that. And law firms have different approaches to that, but it is important to have a discussion to understand who they propose to pay for that, whether they'll be paying for that or the client is going to be paying for that, or whether there'll be contributions from some kind of third party like a litigation funder. But you want to understand the arrangements. You want to understand who gets paid back for those things at the end and how that fits in with the overall risk profile of the case. And the other thing to keep in mind is, okay, what about the defendant's cost? So usually there's not any, or there's certainly very minimal exposure to any risk of having to contribute to the defendant costs in that early investigation stage. But in that kind of worst case scenario outcome, if you actually run the case in court and lose, what would happen then with the defendant's costs? And often there is a risk that there would be a costs order against an unsuccessful plaintiff where they would have to pay the defendant's costs. So that sounds really scary. And
Yeah.
obviously that's the worst possible outcome that anyone could ever
And
have.
that's if it's gone to court.
I think it's a very remote and very rare risk.
Yeah.
But one thing to keep in mind is that that's not happening tomorrow. That's not happening next week. We're talking about decisions that you would make after a process of really thorough investigation and development of the claim, and connecting with experts and maybe getting barristers in to take a look at it. And at the point that you decide to register it in court, and at the point that you decide to progress it onto a court hearing, you have a lot of information and knowledge about how good the case is and how valuable the case is that you can feed into your decisions about what to do and whether to settle and so on, including whether you're prepared to take the risk of running it.
That's really helpful because Kate, I definitely have had women come to me and say that they've been told that they have to pay for their expert witness up front. And that is expensive, isn't it? It's like 5 grand. Like some of the sort of financial implications of paying for an expert witness up front seems kind of counterproductive when people are probably seeking legal action in the first place for loss of income.
Yeah, and so different law firms have different
Okay.
arrangements for that. It's a really important question to ask. I would hate to ever see that be a barrier to a good claim proceeding, and there usually are
Mm.
plenty of options around that.
Okay, thank you. I think we've covered so much. I think before we end, um, let's go. I'm just looking at this last question. So, what is your advice to parents who feel something wasn't right but are unsure what to do next? I think you've kind of covered that. Um, Maybe we should go to the next question, which is, okay, what would you say to someone who feels intimidated or scared to pursue legal action?
That's a really good question. I know that the people I speak with have to some extent already been over that hurdle. They've got to the point that they've been able to pick up their phone, or maybe their partner has, and just establish that initial contact with me. Um, and then I hope we can have a really good conversation around, well, let's do this in a human way where I'm on your side and I'm trying to help you understand and give you information, free, in a no fee environment. So, it's a obligation free kind of guidance session. And I hope that's not too intimidating for people. But yes, you're absolutely right. There would be other people out there in the world who just never make that first call to a lawyer because, even that feels too much for them. And it may be a question of time. So we might be talking about the people who maybe do call me eventually at the 2 year mark or at the 2.5 year mark. And you hope you're still within a period that you can develop their rights. But it saddens me to think that there are people who are so traumatized that even with a good potential case, they just wouldn't take action at all. And I would
I,
encourage,
yeah.
this is not just about me and my firm and the work I do, whichever jurisdiction you sit in, whatever your local lawyers are, I would encourage people to just take that step of sounding things out and seeing where they stand and hearing a bit more about it, and finding out whether they do actually have rights, and then working through the process that exists there, and making a decision about whether that's right for them. Maybe it is, maybe it isn't, but at least you would make that decision
Mhm.
better informed, which is a bit of a theme of our discussion today.
Absolutely. I think of people that are maybe have English as a second language and have birthed in Australia that that would also fall into that category of it's too hard. I can't articulate myself. Do you come across a diverse community in your practice?
I think that's true. I mean, yes, I do have diverse clients. I have acted for many people who are immigrants to Australia or who have English as a second language, or other things. And I think there are definitely um, lots of different people who do investigate these claims. But I think it's also true that there are probably people out there who, for various reasons, their own life characteristics or circumstances
Yeah.
deal with more barriers to
Yeah.
working through the legal process. Um, and probably if they pick up that phone and get in touch with a lawyer to get advice, there might be ways of working through whatever those barriers are. Um, but it's a reality that it maybe stops some people even just picking up that phone.
Mm. What about if someone has already reached out to a lawyer and they are unsure whether this lawyer is actually progressing the case? Like they're slow to respond, but maybe they've signed something to say that they'll work with them and they sort of feel like they can't look elsewhere. Have you got advice around that?
Yes, so first of all, I would say that it is sometimes possible to change lawyers, and probably the earlier on, the easier that is to do. But just to give the lawyer the benefit of the doubt for a moment, I'd say probably the best thing to do is just reach out to them at regular intervals for two reasons. So first of all, you can ask for progress updates, where are things up to, what's progressing, where are we up to, what to expect next. You're entitled to information because you're at the center of all of this. And second, also to give them information. So the lawyer's role is to investigate and present your story they need to understand what's actually happening with you. And I always tell my clients, communicate with us with updates about every 6 to 8 weeks. So have you seen doctors? Are your symptoms the same? Are new things happening with your work situation? Are you dealing with any new issues? Are you planning to see any specialists soon? All of those sorts of things. Or even just all the same, all unchanged, my disabilities are ongoing. And all of that will actually trigger work that we might then do to keep progressing things. So it's important that there be this two-way communication with the legal team all the way along. And if you haven't heard from them for a while, provide your update and reach out and request a progress report.
I think that's really great advice. It definitely is relevant to members of our community where they do feel like things are progressing really slowly and their life is almost in limbo and until they know what is happening, whether there's a case. So thank you for that. Well, I like to think today that we've broken down some of the barriers, Kate. I just want to thank you so much for the generosity of your time. I know how busy you are, and I've really enjoyed this chat. And it may lead to more questions. We may have to do another one of these in the future.
No
But
worries.
yeah, thank you so much.
Always happy to help. First Tremor Australia always has a big piece of my heart, as you know.
Yeah. I'm not going to let you go. So yeah, thank you. Thanks so much, Kate.
All right. Bye.
Bye bye.